I just learned something this morning.
What'd you learn?
Megan has wandered into the studio.
Yeah.
And by law, I'm not allowed to let her talk about this.
Right.
So I get to talk about it on her behalf.
Okay.
You ever heard the Bobby Bear song, Marie Laveau?
Yeah.
Did you know she was a real woman?
No.
There was really a Marie Laveau.
She related to Megan?
No.
Ooh.
Oh, Megan's claiming she is.
She proudly says yes.
Can you go sit on the other side of the glass with that being the case?
What she's doing, I think she's putting a spell on you, Leland.
Marie Laveau was a Louisiana Creole practitioner of voodoo. She lived from 1794 to 1881.
Wow. That was a long time back then.
She performed her rituals at Lake Pontchartrain, and she has a grave in South Louisiana. St. Louis? St. Louis Cemetery of New Orleans. See, Megan knows this stuff.
Mm-hmm.
And the legend is that you can go to the cemetery and make a wish, draw an X on her grave, on her tomb, and if she grants the wish, you come back and circle the X and leave an offering. Somebody has painted the grave pink.
Oh, no.
Hot pink.
Uh-oh.
So, bad things in South Louisiana.
They're in for it sounds like. Oh, man. 8:12 here on Newstalk. Let's go to the phones. Good morning. Is this Wendy?
This is.
Hey, good morning, Dr. Patrick. How are you?
Good, thank you.
Great to have you on the program.
Great to be here.
Wendy's a 20-year veteran trial attorney, prosecutor in the Sex Crimes and Stalking Division of the San Diego District Attorney's Office, author of a couple of books as well. She's co-authored some and helped rewrite some. Let's most of the time, probably 95% of the time, I can stand proudly and say, I'm glad I'm from Texas because we're doing this right, we're doing this right. Look at this. I mean, we got a lot of pride here. But this story is one that I kind of hang my head in shame over. This kid who's he's drunk and on whatever other kind of drugs, crashes his big, bad Ford truck and kills 4 people and doesn't see any time behind bars.
Yeah, don't feel bad that this happened in your state. I can tell you that cases like this, sort of with analogous mitigants, if you will, being touted as reasons that punishment should be reduced occur all over the world, right? It's not just any particular state or country. What really sort of thrusts this into the spotlight, if you will, is really the emotion over the punishment not fitting the crime. Normally, we see that being argued the other way, right? Somebody really gets the book thrown at them, and there's a bunch of people saying, gosh, that wasn't fair. That's way too harsh depending on what he did. This is actually the opposite conclusion. Mm-hmm. This has really been seen, as many people, as a terrible injustice, that for $450,000, this young man will be in Newport Beach, with a therapy pony and martial arts training. Now, there's another side to this as well, though, that's also being argued. This young man is a juvenile that was not tried as an adult. So there's a shield of confidentiality that protects a lot of the underlying facts of the case that we don't know. So we're really all kind of coming at this as, we don't have all the facts we wish we did in order to really make a fair judgment. So we're sort of, reacting to our visceral, feeling that we have looking at the fact that he won't see any time behind bars, because remember, the prosecutors were asking for 20 years prison.
Yeah.
So that's a pretty big difference in respective punishments, depending what they were looking for and what they got.
But you've got 20 years as a trial attorney. Have you ever seen a situation where someone committed intoxication, manslaughter, or something similar, kill 4 people, and walk away with no time incarcerated?
I haven't seen anything like this, and I can tell you I've been both a prosecutor and a criminal defense attorney. So I've argued for mitigating circumstances, and I've argued against mitigating circumstances, right? That's the mark of a good lawyer. You can argue both sides of it. But I got to tell you, this kind of defense has always, and let me first clarify some terminology. It's not a defense in the sense that they argued that it made him not guilty, okay? People keep comparing this to the Twinkie defense, right? Do you remember that? That actually wasn't the nomenclature.
I ate too many Twinkies, I fell out of a tree.
Right, and that Twinkie defense really had to do more with a diminished capacity capacity. In other words, it was put forth in an effort to negate an element of the crime. This is very different. Okay, this hearing was not a trial. This was a 3-day sentencing hearing during which time the psychologist testified as to this sort of rationale why he should get a more lenient sentence. So you don't see this kind of thing as much, if at all, really in the guilt phase. You see different kinds of defenses that are used to say why somebody was or wasn't guilty or is guilty of a lesser crime. That's not what happened here. So it's very different. It's very creative, but it's also very different than, the traditional criminal case that most of us have done, where you're really looking at, did somebody do it, did they not, and what kind of defenses might there be to the crime itself.
Well, you look at, you think of mitigating defenses or situations or that sort of thing. You think of maybe a wife who had been abused by her husband, and one night she killed him during an altercation.
Right.
Right. And it didn't qualify for self-defense, but you can establish a pattern of defense, so we're going to go a pattern of abuse, so we're going to go easy on her during the sentencing because look at all she's had to deal with.
Absolutely. Another great example of that is, you remember Dr. Jack Kevorkian, the suicide doctor? Mm-hmm. He never once said he didn't do it, right? But how many juries found him not guilty? I mean, maybe that's not a good example because we like to think that's an example of jury nullification.
But the mitigating defense here is, Your Honor, my client has had life too good.
Yeah.
He's too rich. He's too privileged to go to prison.
And I also think that this got such notoriety because it came in the midst of some high-profile criminals that had committed other acts of misconduct and were arguably treated more lenient. So it sort of came in the midst of criminals that other people didn't think got the just rewards based on what they've done. But, again, there are so many people that are not rich, that are not famous, that also get enormous breaks. Or, on the other side of the coin, there are lots of cases in which celebrity criminals have gotten, some people think, sentences that were too harsh. So this case is so interesting on so many different levels, but I think the fact that there's this perception that money can buy a better defense or a more lenient punishment really sort of is at the heart of it, because it comes, again, right in the middle of just hopefully turning around out of a recession where many of us are thinking, we wouldn't have been able to afford to have a 3-day sentencing hearing if we had, God forbid, gotten ourselves into an accident and killed somebody. So there's really a personal element, I think, to this that has caused this reaction among back and forth across America.
Well, we've spoken before, and we've talked about the idea that you can buy justice if you have enough money. And you've talked about for every case like the Affluenza defense that we saw here in Texas, there are a number of others that didn't go that way or where the defendant got a harsher sentence because of their privilege. But you really have to look at this. Brian and I, if it had been us going before trial for this same crime, we wouldn't have been able to afford the lawyer to even give us that shot.
That's right, and that's what a lot of people are saying as well, is that, somebody like this really can afford to hire the A-team, the dream team, the top echelon of criminal defense. It's no different than, remember the O.J. case. We heard the same arguments there, is that, it's a matter of being able to get this kind of a defense. But I got to tell you, I started my career as a criminal defense attorney. I was a public defender, right? You represent folks that can't hire private lawyers. And I got to tell you, that is a hard-working job. Those people that defend the indigent are hard-working, they're experienced, and here's why. They're in court every day. I mean, these people, they have the talent, the expertise, the wherewithal, the savvy. This is what they do for a living. They don't handle one case a year. They are they are totally overworked with a lot of cases. Now, some might argue that's too high of a caseload. Others might argue, hey, it's great to be a private attorney and only be able to focus on one case. But there are merits on both sides of all of these arguments, and I understand why the public, maybe is, up in arms when somebody gets off because they can hire a great defense team, because perhaps they don't have the same level of experience with exactly the dynamics of how these different things work to understand that somebody that does this day in and day out may actually be in a position to have more influence in a courtroom simply by virtue of their experience, rather than somebody that costs a lot of money but maybe only goes to trial once or twice a year. So it all depends. That's what really the bottom line is.
And as any good prosecutor will tell you, no two cases are alike.
You bet. And any good defense attorney would tell you the same. And there are some that maybe only go to trial once or twice a year, but they have the time to get themselves, up to speed with the law much better than somebody that has 50 or 60 cases cases. So it really all depends. And we all kind of see when they televise some of these trials, which, there are arguments on both sides of that as well. But when they do, we're all sort of able to deduce, how familiar is somebody with court procedure. We saw a lot of those types of things being showcased in the George Zimmerman trial, for example. Instead of speculating what went on, like we're largely doing here because this young man was a juvenile, we don't have a lot of information because it's confidential. With some adult trial, we're able to see a lot more behind the scenes to understand more why these arguments are being made, whether or not it was reasonable for a jury to conclude the way they did. So we get a lot more insight the more facts we have, and that's hindering us a little bit here because we wish we knew more about about what went on behind closed doors with Ethan Couch's case.
And that brings up another question. Cameras in the courtroom, are you in favor or opposed?
Well, as a prosecutor, we don't take a position on that. But let me tell you what the arguments are on both sides, which is even better. The defense obviously has a lot of arguments about it's not fair to the client, and the reason for that is unless you've sequestered a jury, like the Zimmerman case did, very unusual, by the way, nowadays to have jury sequestration. But unless you've done that, in our world of social media, how can you possibly expect for those jurors to be shielded from all of that, the publicity that high-profile cases get? I mean, think about it. And if you're going to sequester them, can you imagine if I took your iPhone away from you and I said, nope, you know what, I'm going to hold on to this and I'll give it back to you at the end of the week? Your life might grind to a halt, right? So those are some of the arguments against why we shouldn't have cameras in the courtroom. Now, on the other hand, if you don't, what we're going to have, a lot of people argue, is a trial in the court of public opinion. And nobody's, you're never really going to know what's going on. The information is less likely to be accurate because it's all speculation as to what may or may not be happening. So there's a lot of equities involved, and of course there's an underlying theme of, the public is open proceedings. The public has a right to know what goes on in its criminal justice system. So those are kind of the two sides to it. And then, like you said earlier, gosh, it really depends on the nature of the case. There are some cases where cameras in the courtroom can completely disrupt witness testimony just by creating this aura of intimidation. We're doing radio today, but it's a very different dynamic when we've got cameras pointing at our faces, sometimes from a foot away, and nobody wants to see that color the way a witness is testifying.
We're visiting with Wendy Patrick, Dr. Wendy Patrick, about this case in which the young man was, he was indicted for involuntary manslaughter in which he killed 4 people in a traffic accident, DWI, and then was let off with no prison time. What's the reaction within the law community over this judge's decision? Because it was his decision, right?
Yeah, it was the decision of the judge, and judges are not allowed to comment upon why they did what they did, and that's frustrating for many judges because, can you imagine if she's listening to the program today thinking, gosh, I wish I could call in and just explain why I did what I did, but of course they can't do that. Within the criminal justice community, though, there's always a lot of talk about whether or not whether it's fair to be as outraged with sending a young man to a rehab facility, given that really wasn't the Affluenza defense. So there's been really a lot of talk about, wait a minute, the defense to the case wasn't that he, was impaired by substance abuse, yet that is what he's going to be receiving at this Newport Beach facility. It's not a facility to cure Affluenza. So there's sort of a circular argument that doesn't make a lot of sense that folks in the community, that I run in are discussing that, wait a minute, that's not why he's going to a rehab. He's going to rehab to get some help for his alcohol substance abuse problem so this kind of thing never happens again. But what's that going to do about the Affluenza if that, in fact, is a reason we should not have sent him to prison? So, the public may be looking at, gosh, does the punishment fit the crime? But when you really look at the nuances of, what this sentence, if you really want to call it that, if this attempt at rehabilitation really fits the mitigation, it doesn't really. And so there's a little bit of frustration as to whether it's fair on that level as well.
Hey, Wendy, go ahead.
I just had a question because we've gone through the criminal phase of this case. Now there's probably going to be a civil trial. I'm pretty sure the victims' families will probably sue for damages, wrongful death, and that sort of thing. Does the Affluenza defense, will that come back to haunt the father of this young man when they go to civil trial?
That's a great question. One in which I'm sure that whoever is going to be hired on both sides of this is going to consider. Many criminal defense attorneys are making the joke that the Ethan Couch case pretty much precluded anybody from ever really using the Affluenza defense again. On the other hand, this issue of entitlement and how somebody is raised certainly might be something that's raised by one side or the other. And the thing about this case, there are no winners here. I mean, the family of young Mr. Couch is grieving. Mr. Couch himself is no doubt grieving. I represented when I was a defense attorney people that have done this, that have accidentally lost control of a car, whether they're drinking or they're fishing around for CDs or whatever it is. And many of them have said they felt like their lives were over, knowing that they had killed 4 of their best friends. So this is a case where there are no winners. There's a lot of grieving on both sides, and this issue of Affluenza, and will it come up again in a civil context? Obviously we're going to wait and see, but there's no reason why these issues are precluded from being discussed. One of the big things that's going to be different is the burden of proof, preponderance of the evidence versus proof beyond a reasonable doubt. But will the defenses be the same? They are in many other cases, or at least elements of them are still going to be relevant to whether guilt or culpability or punishment. But we certainly may expect to see some of this being discussed again.
Well, it would just seem to me if you went into court and you said the reason that this kid did this was because his father spoiled him, and the father's funding that defense, then it seems like there's almost an admission of responsibility on the part of the father in that case.
Well, the civil cases are tricky when it comes to, who is going to be responsible for what kinds of conduct. It'll depend on a lot more things than in a criminal case where there was a real hard and fast law that this young man was prosecuted under. And also in criminal court, there's the issue of restitution. So if you're culpable for something, there's a restitution hearing, and, everybody decides what's fair, what are the financial losses that stem from the crime. Civil court, it's very different. And, and I wouldn't expect the civil attorneys to really show their hand ahead of time, which is what's so interesting about all of us speculating about what's going to happen. Sometimes that's, it's fun to actually watch the case and see who was right about what the issues are going to be. So while it's premature to know exactly what they're going to argue, it's fair game to talk about what could be relevant to the kind of charges and that we're going to see in the civil trials that we already have heard are going to be pursued.
Wendy, where can folks get copies of your books and follow you?
Everything's on Amazon. I'm on Twitter. The Reading People is on Amazon. My book, The Psychology of Attraction, is on Amazon. There's a lot of information about these sorts of things really kind of out there in the court of public opinion. It's a wonderful thing to know that people are interested in learning more about the criminal justice system, because knowledge is power. And the more folks understand why things happen in the courtroom, I think will temper a little bit of the outrage that some people feel when they read about a decision that at first blush may not seem fair, but when you read more about it may at least be more understandable when you look at the facts of an individual case.
Great to get to visit with you, Wendy. We appreciate your time, and all the best to you in 2014.
Yeah, my pleasure, and Happy New Year to you as well.
All right, thank you. 828 here on News Talk 102.3 and AM 1240 as we get on to the Osgood Files.